Thank you. Thank you very much, Maureen. First, I want to thank the university and law school administrations, the Liakos family, Louis and Maurice Fox and Ed Swartz, for establishing this chair. The chair is named after Paul Liakos, who was for a relatively long time the Chief Justice of the Massachusetts Supreme Judicial Court. Justice Liakos graduated from Boston University School of Law in 1952, and as Maureen mentioned, it happens that my father was in the same class. My father was a classmate of Paul Liakos, and he remembers Paul Liakos fondly. Even though they were just law students, my father remembers Paul Liakos for his honesty, integrity, keen intellect, warm personality, and his apparent sense of and desire for justice. These were obvious attributes of Paul Liakos, even as a student, and they were consistently borne out through his career in the law. These attributes are all part of the signature that Chief Justice Liakos left in the Massachusetts Supreme, in the common law of the Massachusetts Supreme Judicial Court. Paul Liakos, in his capacity as Chief Justice, joined a small number of distinguished Massachusetts jurists, including names such as Lemuel Shaw and Oliver Wendell Holmes. The Massachusetts Supreme Judicial Court, in operation since 1692, is the oldest continually functioning appellate court in the common law tradition outside of England. Well, there's one last thing I want to say about Paul Liakos before I move into the text of my remarks. Law, sort of like religion, is a field in which the differences between ideals and practice and the ideals that are spoken, the lofty ideals spoken by practitioners and their actual practices are continually on display. In 1952, when Justice Liakos and my father graduated from this law school, this country was a very different place in terms of the distribution of opportunities and rights among citizens. For example, the separate but equal doctrine of Plessy versus Ferguson was still the law in 1952, and it was enforced in my father's native Virginia. So the conditions of the time provided numerous opportunities for Paul Liakos and my father to observe the differences between ideals and practice in the law. The law often fell short of its own ideals, and many lawyers did not make the effort. My father remembers Paul Liakos as a man who did not fall short of his ideals, as one who tried to live according to the ideals of justice he had embraced. I'm going to turn now to the text of my remarks for today. The topic is tort scholarship, and I won't be saying much about torts case law or about hot topics such as malpractice reform. So this lecture will be comparatively dry. I will focus on interdisciplinary writing in tort law. That is, writing that draws on ideas from disciplines outside of law to inform analysis of tort law. For those who are in the audience who are unfamiliar with the field of torts, torts is the law governing accidental and intentional injuries. But torts also runs into issues of consent and ultimately autonomy. These were important issues in two of Justice Liakos' opinions for the Massachusetts Supreme Judicial Court, Brophy versus New England Hospital, Incorporated in 1986, and Superintendent of Belchertown State School versus Sakowicz, two important decisions dealing with the issue of autonomy and also issues in tort law. The type of law we focus on in school is the common law, that is the law produced from court decisions. As I tell my first-year students, in many ways, torts is the core of the common law. Torts has nothing to do with promises that people make or with criminal statutes specifying conduct that is prohibited. In the simplest version of it, contract law is all about enforcing promises. The tripwire that causes you to be forced to pay damages is one that you set yourself in agreement with the contracting party. And the tripwire can take any shape depending on the preferences of the contracting parties. On the other extreme, there's criminal law. The tripwires in criminal law are ones that society has fashioned after the long experience. It has reached the conclusion that certain acts should be prohibited and that society should punish those who violate the rules, whether or not there is a victim who is prepared to bring a suit for damages. Torts is different because it involves society, through the judicial process, fashioning rules that it will apply to all of us. The tripwires are not set in agreements. They are set by the courts. The tripwires are not fixed from long experience, as in criminal law. They are continually adjusted and new ones formed all the time. Unlike criminal law, potential defendants are not really on notice about the rules. The rules are often fashioned for the first time in a new case. You could say that potential defendants are on notice about the principles of tort law, the principles from which the rules are fashioned, but not on notice about the rules that will be applied in their cases. So this is what the common law process is. It's the development of new rules and norms by courts as they confront new problems. And this is torts. This is what torts is all about, and it's the common law process in its quintessential form. As Oliver Wendell Holmes said in his book, The Common Law, published in 1881, the business of the law of torts is to fix the dividing line between those cases in which a man is held liable for which he has, well, actually, I inserted a word I shouldn't have in there, between those cases in which a man is liable for harm which he has done and those in which he is not. Holmes said he would try to discover, quote, whether there is any common ground at all at the bottom of all liability in tort, and if so, what that ground is. I'm continuing with the quote, supposing the attempt to succeed, it will reveal the general principles of civil liability at common law. This is a typically bold claim of the sort that you'll find in Holmes's book, but I assume it should be taken at face value. Holmes is saying that if he can understand tort law, he can understand the general principles of civil liability. It's unfortunate that torts courses have been cut back in law schools over the past 25 years. Now the courses run for a semester, and a generation ago most torts courses lasted for a year. That meant that they covered a lot more material, all of the material that you see now in your first year torts class, plus other topics. I have one of the better, or maybe the best, torts casebook from many years ago, John Henry Wigmore's torts casebook from 1912. It covers everything that we cover today and more, so more than we could ever cover in the regular torts class. Plus it covers topics that we would consider intellectual property now, things like the topics such as trademark, trade secrets. And it was clear that Wigmore felt that once you understood the principles of tort law, you could understand a lot of other topics that were related to tort law. And so what this suggests is that if students had a better grounding in tort law, they would be in a better position to understand many areas of law that are treated today as new or unrelated topics. Well, okay, so that's something to think about. I want to add that I certainly don't want to do the extra teaching, though, if we return to a full year torts class. Now I'm going to start focusing on torts scholarship, which is, again, the subject of this talk. It's traditionally focused on understanding or critiquing the common law of torts. However, the way that it has done that has changed a lot over time. Traditionally, tort scholarship has involved two competing schools, corrective justice theory and utilitarianism. The corrective justice work typically draws on Kantian ideas, and the utilitarian school draws on a framework of analysis that has had a long history. The two schools are still the key ones, but the approaches taken within them have changed a lot. In the past, the scholarship involved largely discussion of the case law. Today, the scholarship involves largely discussion of the case law, but things have changed a bit. There's a deeper dive into related disciplines. So for the corrective justice theorists, they typically draw on the work of moral philosophers, the style of arguments that many of you saw last week in the conference in honor of Ronald Dworkin. For the utilitarian school, they draw on the work today of economists. The other two branches that are new are mathematical modeling of incentives in the tort system using standard economic modeling methods. And the other new approach is empirical, which attempts to take data on injuries and relate those data to changes in the tort law. Now I want to talk about the history of tort scholarship. So if we take the definition of interdisciplinary scholarship in its broadest sense, it involves any writing on law that draws on ideas that have not been generated in the law itself. By that definition, interdisciplinary legal scholarship has been around for a long time. It probably has its clearest starting point with Jeremy Bentham, and Bentham, I think, is the best person to start with. Bentham is widely considered to be the father of utilitarianism. Bentham had some nutty ideas, not nearly as nutty as some of the things that law professors say today. I don't think Bentham ever argued that animals should be represented in court by lawyers, but he had some other fairly nutty arguments that I won't go into. Bentham thought that the common law was deficient in many ways. He famously referred to it as dog law because it failed to provide notice to people that it applied to. That is, it failed to provide notice to everyone. So Bentham's famous example was he said, well, how do you teach your law? How do you teach your dog? How do you teach your dog how to obey the law of the house? He says, well, you let the dog do something wrong and then you punish the dog. He says, well, that's the way the common law works. You know, no one ever knows how it works. You do something wrong and then you get punished. So he referred to common law as dog law. He was in favor of scrapping the common law and replacing it with his own codification scheme. And fortunately, he was totally unsuccessful in that effort. Bentham's contribution to tort law was largely negative. His criticism of the common law, and specifically the vision of the common law presented in Blackstone's commentaries, led him to ridicule the reasonableness standard on which much of tort doctrine is based. Bentham did not believe there was anything to the reasonableness standard. To him, reasonableness meant, I like it, something I like. If it's in something that's not reasonable, it's something I don't like. At bottom, Bentham believed that we are independent, self-interested, utility-maximizing machines. We care for others or the opinions of others, in his view, only so far as doing so may enhance our own happiness. There was no real ability, in his view, among humans to be impartial, and any attempt or expression of impartiality was an effort to fool and manipulate the gullible among us. For the most part, Bentham was unsuccessful in promoting this view of the law, but it is still strongly associated with positivism, the notion that all of the law is in the books, and much of utilitarianism. In fact, you could say it is the piece of both positivism and utilitarianism that overlaps. It is also the piece that legal scholars inclined to argue on moral grounds, such as Ronald Dworkin, have taken aim at. The more important part of Bentham was his effort to provide a system of taxonomy for motivational concepts relevant to the law and to model the incentives created by the law. His works vary from an in-depth discussion of preferences in psychology to efforts to apply a system directly to the law. Moreover, it was clear that Bentham was interested in using his framework to understand the law, the sources of the policies reflected in it, and to understand its reform. I will not focus on the corrective justice school. I'm not entirely familiar with all of the work done in that area. However, it seems that the sources that it's drawn upon are more inward-looking than Bentham's writing. That is, it appears in the Kantian arguments there was a focus on trying to develop a science of ethics first, which may have implications for law. Bentham, on the other hand, was clearly interested in trying to explain or understand the policies behind the law. So, as I said, we have Bentham starting off, and Bentham is a critic of the reasonableness standard that's core to much of tort law. And that, you could say, is the start of interdisciplinary legal scholarship. After Bentham, at least in the area of torts, we have Holmes, Oliver Wendell Holmes, as the next interdisciplinary treatment of torts. Holmes never advanced any nutty ideas, and he attempted to use utilitarianism to defend the common law. He did so at a fairly high level of detail, a greater level of detail than he has been credited for by Richard Posner, though Posner has obvious incentives to minimize the value of the work that Holmes did on tort law, and I'll come back to that later. As interdisciplinary scholarship, Holmes is inferior to Bentham. That is, if you want to see some effort to develop a science with direct application to law that is independent of the law itself, then Holmes is inferior to Bentham. Bentham tried to understand human behavior and to use that understanding to critique the common law. Holmes tried to understand the law, relying on utilitarian arguments to fill in the unstated policies reflected in it. Of course, if you want to understand the law and the policies it reflects, Holmes is superior to Bentham. Bentham was largely normative, and I mean normative in the sense of trying to offer a system that tells you how to remake the law, how to remake the common law, how to do it differently and better. Holmes, on the other hand, was largely positive. He looked at the law as it is and tried to understand it, tried to understand its policy bases, and largely defended the law on defended the common law on utilitarian grounds as it was at the time. And these are two different approaches, the normative approach versus the positive approach. That those two approaches account for all of the scholarship, the law scholarship that's out there today. It's either normative or it's positive. After Holmes, the next generation of interdisciplinary scholarship would not appear until the law and economics movement began with people like James Buchanan and Ronald Coase. So that's roughly a 100-year break from Holmes to the next big movement in interdisciplinary legal scholarship. At first, you see a shift. In the first wave of law and economics writing, we see a shift from the utilitarian theory of Bentham to mostly straightforward economic analysis. Bentham, you recall, was willing to incorporate any ideas that seemed descriptive of human reality in his utilitarian model of human behavior. If people acted irrationally in some context, Bentham would incorporate that into a system. For example, Bentham argued for punishments that had a characteristic quality. By that he meant that the punishment should remind the potential defendant of the crime that he's committed and make him think more about avoiding it. So, for example, a thief, Bentham suggested, should have his hand cut off. When we get to the School of Law and Economics, the first writing, we don't see that kind of freedom or lack of restraint or imaginativeness in building a theory, at least initially. The first wave of law and economics writing was, again, straightforward, standard economic analysis. The next, I guess, important writing in the area, and it reflects a departure from that, is the book by Guido Calabresi. Guido Calabresi published The Cost of Accidents in 1970, and Calabresi is a federal appellate judge and one of the early writers in the law and economics of torts. Calabresi was a behavioral law and economics scholar long before the behavioral school appeared. In other words, he actually, like Bentham, he took into account the possibility that people would act irrationally and tried to incorporate that into his model of behavior. So this puts him in the same camp as Bentham. He was also in the same camp as Bentham because Calabresi was a critic of the common law. Like Bentham, Calabresi set out reform proposals that can be accurately described as impractical. He wanted to scrap the negligence system and replace it with strict liability doctrines, loading liability onto a person called the cheapest cost avoider. His contribution to thought is important, but his reforms were not adopted, and they will not be. I think this takes us up to Posner. So this is a quick bird's eye view over a lot of interdisciplinary scholarship. Posner is probably the most cited legal scholar in existence. Of course, citations probably shouldn't be treated as a measure of the worth of a scholar's work. Karl Marx is probably the most cited theorist of any sort, and look at what his writing has done for humanity. If Engels' family textile business had failed, leaving him no money to support Karl Marx, I can't say the world would not have been better off as a result. Posner has to be looked at primarily as a torts theorist, although he has written on every topic under the sun. I mean, if you just think of a topic, any topic, chances are Posner has a paper on that topic. But he began largely focusing on tort law, and much of the theories that he brought to law were designed for torts and focused on torts. And as a scholar of the common law, and particularly of tort law, Posner is famous for the economic efficiency thesis, the argument that common law is economically efficient in the sense that the rules appear to minimize the costs of injuries, of avoiding injuries, and maybe legal administrative costs as well. As a torts theorist, Posner has largely been within the framework of Holmes. Posner has contested this himself. He has described Holmes' writing as leaving unclear precisely what theory explained the development of the common law. But this is false. Holmes says clearly in the common law that he believes, in his book, The Common Law, that he believes the law to be shaped largely by convenience. And back in 1880, when Holmes was writing, convenience was probably as close as anyone would come to saying economic efficiency. So there were arguments in Holmes in 1881 that largely anticipate much of what Posner had to say when he broke into the field. Still, I do not mean to discount the novelty or value of Posner's writing on tort law. He has drawn the connection between economics and law more closely than anyone before him and is almost single-handedly responsible for the development of the modern law and economics movement a movement that includes among its promoters, lawyers and judges, as well as law professors. All this can be accepted as true without exaggerating the degree of novelty in his work. As I mentioned, Holmes had applied utilitarianism to tort law before Posner had anticipated many of the arguments that were central to Posner's work. Another earlier voice was that of Adam Smith, known for the book The Wealth of Nations. There's another book under Smith's name called Lectures on Jurisprudence, which it's largely a set of lecture notes from a class that he taught. And in that book, you'll find an economic account of the common law there, roughly 200 years before Posner, 100 years before Holmes and 200 years before Posner. So there's a tradition of positive economic analysis of the common law that you could say arguably begins with Adam Smith, Holmes, and Posner. And I think there's some real value coming out of that scholarship. I think that's the question that an outsider to scholarship would be inclined to ask. So there's all this writing, so what good is it? What is it giving us? Well, I guess the first thing to say about it is that ideas are important, and you can always cite Karl Marx for that proposition and leave it at that. Second, courts and legal policymakers are always in search for the policy grounds for the law. The policy grounds need to be stated to provide some measure of consistency and permanence to the law. This is most obvious in the other area in which I teach antitrust, where you can almost predict the antitrust doctrine that's about to be overturned by how the policy arguments are going. The policy arguments are all running against that particular doctrine. If all the articles in the journals are saying that the doctrine is a dumb idea and it ought to fall, then you can predict that that doctrine is going to be overturned pretty soon. The policy grounds provide the reason behind the law, and the policy grounds have to be stated with sufficient particularity to be of use in deciding and distinguishing cases. So it's not enough for scholars to say, well, they're broad maxims that courts ought to follow. You know, people should not lie. People should keep their promises. So the policy grounds have to be stated with more particularity than that. This is crucially important in the common law system. The law is obviously important, but as Holmes stressed throughout his book, The Common Law, the policies are equally important. If the policies are forgotten or corrupted in some sense, the common law soon goes with it. Posner has worked very hard as a scholar and judge to broaden the policy capital of common law courts and the ability of judges and lawyers to understand it. This is an extremely valuable contribution. His work is focused on providing a positive, explanatory theory of law, which is of direct use to courts in explaining and understanding the common law. So now that takes me up to the present. And I said in the brief description of this talk that I would give a candid assessment of interdisciplinary legal scholarship. So we're here. This takes us up to today because Posner is alive and still writing. So we're up to the present. So the question I want to ask is, does interdisciplinary legal scholarship, where does interdisciplinary legal scholarship in torts stand today? Is it a success? Is it a failure? Does it have any purpose in the law school? I should note that given the view expressed by Holmes in his book, The Common Law, when he said that if I understand the ground for tort liability, I think I understand the ground for civil liability in general, I think if the answers to these questions about interdisciplinary scholarship in torts provides an answer also for interdisciplinary scholarship, legal scholarship in general. So overall, where does interdisciplinary legal scholarship stand today? Well, I think it's a mixed picture. The successes I have alluded to already. I think interdisciplinary scholarship has broadened the policy capital of courts. This is true of the positive theory school of law and economics and of much of the empirical and theoretical work that has gone under the same mantle. I am less sure of what to say about the corrective justice school, in large part because I'm not following it closely, and also because of the disparate treatments in that literature. Although most scholars in the corrective justice school refer to the same sources, there is no established framework of analysis from what I can see. Every corrective justice theorist has his own corrective justice theory, and you can see this if you just look in the early work in the field done by Richard Epstein, Jules Coleman, Ernest Weinrib, or Charles Fried. You see very different accounts of corrective justice theory and what it implies for the common law. In comparison, there is no need in law and economics, at least from what I can see, to refer to the law and economics of Posner or of Calabresi or whoever. There's a framework of analysis, and that is it. And it's a framework, not what Posner said or not what Calabresi said, that has worked its way into the law in several areas. Now, there are excesses too, and I should mention two general categories. One is normative theory in general. The other is a tendency within each discipline that works on the law to speak to the discipline itself, that is the related discipline itself, with little concern for its value or relevance to or workability within the legal system. So I will call this the disconnect problem. So first I'll say a few things about normative theory, and that's the approach that Bentham kicked off many years ago. Again, it's an attempt to state what the legal system should try to do, how things should be done differently. Now, a critique of normative theory will not endear me to fellow law professors. Normative theory is what many of the best-known names in legal scholarship do. Its value to the courts in the torts context has so far been unclear. There are important contributions from normative theory, and I don't want to discount those. Normative theory often identifies what we should be worrying about in the law. There's always a heuristic value in normative scholarship that should not be discounted. There are famous examples of this, such as Calabresi's Costs of Accidents, published in 1970. When Calabresi published his book, it was the first comprehensive theoretical analysis of the tort system after Holmes's book in 1881, so roughly 100 years after Holmes. And Calabresi explained how to think about the tort system as a system. And that's important. That was important for people to learn about at the time and still today. But normative theories often build on models that rely on false premises or premises that fail to capture very important features of the problems that courts have to confront. In fact, it is often a key part of a legal reform theory to ignore crucial parts of the problem courts already face. They typically ignore the learning that is already reflected in the common law. They are often premature in the sense that they proceed before we have a good understanding of the problems that need to be solved. Much of this is true, for example, of Guido Calabresi's Costs. Even though I'm a big fan of the work, I have to recognize what I think are its shortcomings. Calabresi did not, to his credit, build on premises that failed to capture the problems dealt with in the law, but he did ignore the learning already in the common law and was premature in this sense too. I think this charge is even stronger against much of the modern normative scholarship in law and economics. There's also the disconnect problem that I referred to. I see it all the time in law and economics since I'm working in the field. Scholars build models that are based on the flawed premises of earlier models. So over time, a delicate scaffold is built that is based on some unsupported pieces. Many scholars in law and economics read the writing of established scholars in the field and make no attempt to question it or to ask whether it accomplishes its task. Interdisciplinary work in law means looking closely at the law and the problems it confronts. In the field of law and economics, too many scholars ignore this part of the job. They're not looking closely enough at the law and the problems that the law confronts. There are strong incentives in the interdisciplinary area to ignore the law and many of the facts that it's built around. There's always a desire to be recognized by the scholars of the related discipline, in my case, economics. There's also a desire to be recognized by the established scholars. So there's a tendency to simply build on the work of the established scholars without taking a fresh look at how well the existing work takes into account important features of the law. So all of this leads to what I've called the disconnect problem. The end result is a body of literature that is complicated and builds on previous work, but in the end is of questionable value to the legal system. To some extent, this is a problem that is infecting peer-reviewed journals in law and economics. Now I said I would talk about the future, and now is a good time for me to talk about the way forward, the future. And I said I'd say how I'd address the question how the law school itself could improve the work done in the interdisciplinary area. So the law school itself can and should play a role in guiding and developing interdisciplinary legal scholarship. First, one might ask whether the law school should play any role at all. There are legal scholars who feel that the law school should not support interdisciplinary scholarship. The view has played a prominent role in every faculty search I've seen at more than one school. The view that the law should be interdisciplinary is an old one. William Blackstone, in his commentaries on the laws of England, devotes the first chapter to the subject, and this is in 1765. Blackstone argued in favor of interdisciplinary scholarship in law. He offered a model of the law school that envisioned it as joining in a common enterprise with the rest of the university. An individual could learn how to practice by serving as an apprentice to an existing lawyer, and this is how people became lawyers back in the 1700s. The law school would be different in Blackstone's view. It would be a place where the student got a chance to look at the law from a broad theoretical perspective. He argued that the law should be integrated with the rest of the university and that there was no field of study that should be considered absolutely irrelevant to law. And remember, this is 1765. I think Blackstone had the right model, though it has had to be defended at every turn and is under attack even today. It is going to be attacked even more in the short run as the legal market deteriorates. People will say that now is not the time to teach theory, now is the time to teach skills. I don't believe the law school has a comparative advantage in teaching skills, and the practice is probably too broad for us to teach all of the skills needed for practice, even if we tried. We would inevitably send a large percentage of graduates out without developing the skills immediately necessary to perform their jobs. And there is, in the end, a big question about what it means to teach skills. Which skills? Are we talking about the skills of a Supreme Court justice like Shaw, Holmes, or Liakos? If we're going to teach those skills, then we're going to have classes that operate on a pretty high theoretical level. Shaw, in 1842, wrote an opinion called Farwell that makes many sophisticated arguments about assumption of risk and contracts and the grounds for strict liability. These arguments could not even be taught very well in an educational program that focuses entirely on skill development. A skill focus could prepare students for the first day of practice while leaving them not very well prepared for life as a judge or policymaker in the law. Looking at the issue from the academic side, the law school is the best place for the development of interdisciplinary scholarship. The traditional departments do not have scholars who know enough about the law to direct scholarship or teaching that is directly connected to law. And the incentives are different in the special disciplines. In the economics department, the scholars there are interested in pushing the bounds of that field. The best scholars are working at broadening and deepening the intellectual capital of the field of economics. That is their comparative advantage. We should not expect them to start directing scholarship on law. If the interdisciplinary model is accepted, the big question that remains is how to manage it. Of the schools that have adopted interdisciplinary scholarship, not all of them have managed it well. Here are some of the pitfalls. First, when the law school attempts to go in the interdisciplinary direction, it then becomes something like a faculty full of different disciplines that has to make agreements on hiring. That is often a recipe for bad results. The economists who were liked the most by some other schools of thought within the legal academy are not necessarily the ones considered the best trained among economists. Responsible interdisciplinary hiring and promotion should involve a system that effectively puts more weight on the views of established scholars within the same discipline as the candidate. It may require also getting the input of someone in the Faculty of Arts and Sciences in the related discipline, for example, economics or political science or philosophy. If, for example, you are hiring a person to do scholarship in law and economics, it makes sense to have people who know the related discipline best, carrying more weight in the review process. This may seem obvious, but it does not happen all the time. The resulting process is one in which it is sometimes difficult to hire the best candidates in an interdisciplinary field. To some extent, the movement to make the law school interdisciplinary has to be managed from a high level. Central administrations should seek the inputs of scholars in the related discipline on the hiring and promotion of interdisciplinary scholars at the law school. Deans and department heads may have to have discussions about interdisciplinary scholarship. I mentioned the disconnect problem as one that affects interdisciplinary scholarship. The law school can do something about that too. The key step here is to discourage interdisciplinary scholars from turning inward or away toward an inward focus on the related discipline and away from the law. So teaching in the law school itself will have that effect on its own. It will force interdisciplinary scholars to think about issues that affect the law and real lawyers. Interdisciplinary scholars will have to remain integrated within the law school curriculum and not allowed to drift off and teach very specialized interdisciplinary courses. That may mean, for example, team teaching if necessary on some standard bread and butter area in the law. The journals present another issue, and recall what I'm now thinking about is what can the law school do to improve the product, what's coming out of interdisciplinary legal scholarship. Now I want to take a look at the journals. Some law schools control interdisciplinary journals. University of Chicago controls a few interdisciplinary journals. We're not controlling any interdisciplinary journals, peer review journals, so I guess this doesn't, Boston University doesn't have to worry about that issue. But we do run a law journal, and the law journals have played a role in the development of interdisciplinary legal scholarship. The questions that can be asked here are obvious. If you look at any field of scholarship, the premier journals are run by senior scholars. Just look around. Quarterly Journal of Economics, Journal of Political Economy, that's in economics, but choose any other field. In law, we observe something unique. Students run academic journals. It is well known how this came about. The law journal originally was a place where professors published highly developed class lectures, and there was no question about whether the students would accept the papers. 100 years ago, when someone like John Henry Wigmore wrote a survey of tort scholarship, he did not have to worry about whether it would find a home in a prestigious law journal. Now things have changed. The journals get hundreds of submissions, many of a high academic quality from outsiders. The students now stand as gatekeepers of academic journals. This is not a good setup. Imagine what would happen in engineering if the journals were run entirely by students. I would worry about traveling over bridges. Most law students, after completing only a first year in law school, do not know enough about the literature in a given field, such as psychology or economics or philosophy, to distinguish papers that make a substantial contribution to the literature from those that do not. This is an especially serious problem in the context of interdisciplinary legal scholarship. Can the university do anything about this problem? Obviously, yes, and to some extent, the universities have begun to address the problem. Some law reviews run several symposiums a year, and so this has constrained the freedom of students to act as general gatekeepers to a body of academic journals, and that's a sensible policy. In the end, though, it strikes me that some big changes will have to take place. Faculty members may have to take over at least part of the job of running the law reviews, perhaps in exchange for a lighter teaching load. It would be within the interest of every law school to entice senior and productive scholars to do the job. Those scholars should be encouraged to make most of the gatekeeping decisions, or to do so by seeking the advice of outside specialists. This change might have some beneficial effect on the hiring incentives within the law school. One reason, for example, that it may be difficult to make senior lateral hires in law schools is that there is no common enterprise that senior professors engage in. Running a journal could be that kind of common enterprise that gives senior professors an incentive to go out and hire senior lateral scholars. I am not offering a recipe for a utopia in the law journals. There are many problems that would need to be ironed out in this system. Many law professors have not grown up in a system of peer review, so they have no experience with the norms of peer review. There would need to be a great deal of practice to get the system to work well. But in the end, it is the kind of change that must be made in order to get the right product from interdisciplinary legal scholarship. Whatever steps are taken to improve the development of interdisciplinary legal scholarship in the law schools, it is here to stay and is likely to grow within the law school. For reasons I have already alluded to, it is unlikely to find a firm base in the Faculty of Arts and Sciences. Its home will be in the law school. Blackstone's vision of the law school was perhaps a quarter of a millennium ahead of its time, but it is starting to become a reality now. Torts has been and will remain a major testing ground for interdisciplinary legal scholarship. If the process of guiding and developing interdisciplinary legal scholarship can be managed well in the torts area, then, echoing Holmes, I am inclined to believe that it can be managed well in general. Thank you.